Okay, so this is a case in the name of Vestel Elektronik versus HEVC Advance. The reference is A3 2020 0019. Thank you.
Thank you very much. Mr. Chaxfield, this is your appeal. Can I start by thanking everybody for the agreed timetable, and we will have the breaks for the transcribers that have been indicated. The court has read the judgment and the skeletons, so we have a fair idea of the issue. And we proceed. Could you tell me what your understanding is of what you have permission for and what you still need permission from this court for? I think we're disposed to allow you to run all the arguments on a provisional basis, but I think we need to be clear what it is that you have permission for and still need us to determine. Yes.
Yes, my lords and my lady. Of course, I'll address that very shortly. I appear with my learned friend Mr. Edwards, the appellants, as you know, Mr. Segan and Mr. Pickford are here as below for Advance and Phillips. My lord, I will come on very shortly, if I may, to address what the point that my lord has raised as to in respect of what permission is needed or not needed. By way of outline, however, my submission is that I have permission on almost every point of amendment, other than the one that was in fact live before His Honour Judge Hacon, and that I have permission to run all the points that I wish to run pursuant to the order of Mr. Justice Floyd from February last year. But I will talk you through the detail and I'll show you through the documents. I am proposing to spend a few minutes on that because it's obviously very important given the content of the skeleton arguments that are put before the court.
Yes, thank you.
In terms of housekeeping, there are some confidential materials before the court. For myself, I'm hoping that we won't need at any point to go into camera, but I would ask for a 3122 order over the confidential bundle and also tab 23 of the supplemental bundle, which was my client's skeleton argument below, insofar as it contains confidential material highlighted in grey. I've talked to Mr. Segan and Mr. Pickford about this, and we are all in agreement, but obviously subject to my lords and my lady.
It's not obvious to me, which shows how little I've read, the extent to which we'll need to get into the confidential materials. But if we do, I wouldn't have thought there'd be any difficulty in a 3122 order.
I think I'm only proposing to go to one confidential document, and I can obviously flag that at the time.
Yes, thank you.
In terms of the structure of my submissions, after a brief outline of the facts, I propose, as I've said, I propose to address my lords and my lady on the following topics in this order. So firstly, the procedural context.
Yes.
Then the parties and a brief introduction to the background facts.
Yes.
Third, the pleading.
Yeah.
Then Gateway 11.
Yes.
My fifth subject is tort. That's Article 7.2 against Phillips and Gateway 9 against Advance.
Yes.
6 and 7 are extremely brief indeed, and those are Gateways 3 and 4A.
Yes.
Then there's no serious issue to be tried, as 8, and 9 is forum convenience.
Thank you.
I should also mention, I don't think there's any dispute about this, but this is post-Brexit still a case that's governed by the Brussels regulation. That is Article 67(1)A of the withdrawal agreement.
You might need to show us that, because it was something that occurred to me when I was reading the papers. If you were starting the case today, you would not be able to rely on the Brussels Convention against Phillips. Is that right?
I believe that is correct. My understanding is, that I've not looked into the detail of this, is that currently everything would be under CPR 6. Yes. But I think there are ongoing discussions as to what should be done in respect of former Brussels Convention relationships.
Yes, well, I understand that, but as I say, if you were starting afresh today, I don't think the Brussels Convention would apply. And one of the points that is taken is you're trying to change your horses at a very late stage. And it did occur to me to wonder whether if you were changing your horses to something now which, if you started again, would not be within the Brussels Convention, whether you can, as it were, hitch it on to a case which did start before the end of the transitional period, but where the court rejected jurisdiction. We might want to look at that a bit. I'll just flag that at this stage.
No, that's a very interesting point, my lord. My basic submission in terms of what I can and can't run in terms of the substance as opposed to amendments is that permission was granted in February last year by Lord Justice Floyd. So if I'm right on that, then my lord's little nugget doesn't arise, but otherwise it's correct. We may have to think about that, and I don't think any of the parties have so far addressed that point.
Well, I haven't got my head around the detail of it, but I got the impression, at any rate, that some people think that some things only came in last month.
Certainly some people appear to think that, and
yes.
That's something we need to discuss.
I think we need to look at that quite closely as to what came in when and what the consequences might be for the Brexit position.
My lord, and I'll address that once I've just, if I may, done a brief outline of the arguments.
Yes. Thank you.
So at its core, my lords and my lady, this case is about whether and to what extent the patentees would be entitled to relief from for the infringement of their UK patent rights. Vestel's position is that were the declaration sought to be granted, that would provide a complete or alternatively partial defence to any future UK patent action. The respondents would be in the fork of a dilemma after the grant of such relief, because either they would grant Vestel the licence determined by the court, or they would not. If they grant a licence, then any patent claim would fail, obviously. And in fact, the reality is, in our submission, that if a FRAN declaration is made by the court, then Advance will offer this licence. And the reason I say this, and I'll expand upon this later, is that if they do not offer such a licence, then the pool represents an agreement, or one might say cartel, amongst a substantial number of standard essential patent holders by which they agree to charge what have been determined to be supra-FRAND rates. Now, the Article 101 and 102 issues that would arise there would be substantial. Alternatively, if, however, Advance did not offer the FRAND licence, then the declarations would be useful in at least 6 ways. First, it's my client's primary case that an action under the UK SEPs would be demurrable as either an abuse of process or for breach of Article 102 by the patentees. In effect, in response to a claim, we would plead, you can have no relief unless you offer us a licence, the terms of which are res judicata between us. The second reason that there would have a declaration would be of utility is for reasons which I'll explain in more detail later. A declaration would also make it impossible or highly unlikely that a claim could be brought against Vestel for reasons arising out of the terms of the agreement by which the advanced patent pool is set up. I'll take you on to that, and that is the confidential document that I anticipate I may need to go to. Third, in any event, even if an action could technically be brought, then the claim for relief would be barred as abusive or under Article 102. Fourth, in the alternative, at a very minimum, the claim for the injunction, which is really what matters in these cases, would be barred. Fifth, and in any event, the present uncertainty for Vestel as to exposure in the UK market at least would be resolved, because it would know the numbers. And 6, additionally, a declaration from the UK court may have utility, or what you may have seen referred to as spin-off value, in other EPC jurisdictions, which is something I will address you on in more detail later. Now, the present action is most unusual in that it's the implementer which brings this action before the court, and it's the patentees which are resisting having the court declare what the FRAND terms should be. Now, Mr. Siegel and Mr. Pickford will no doubt tell you that their terms are FRAND, but it's striking how little courage they have in that conviction. So they have chosen to resist having an action here to determine the FRAND terms, and instead have chosen to bring patent assertion proceedings in Germany instead. As for the geographical scope of this case, the UK is Vestel Group's largest market worldwide for televisions using the HEVC codec. And in excess of 90% of the Second Defendant sales are in the UK. So the subject matter of Vestel's claim is the UK SDPs in the advanced portfolio. And in that sense, this action is like the actions brought in Unwired Planet, Conversant, which also concerned UK SEPs. Now, it is correct that all the parties have in negotiations proposed licenses of a worldwide scope. And it's also correct that on that basis, it seems likely that the court will, if this action proceeds, determine a worldwide license. Although that's not a given that it will necessarily do so, it will depend on the facts of trial. But in that, this action is no different from the Unwired Planet and Conversant cases, in which global licenses were sought based on the licensing of UK standards essential patents. My lords, that's my outline, and I was now going to turn to procedural context. And as my Lord Justice Nugee has made plain, it is really important in this case, I think, to provide some clarity on the arguments which are before the court and the roles of the amendments in this case, and whether and to what extent permission is needed by my clients on any of these. Now, there are...
Just before you move on, Mr. Chacksfield, going back to your geographical extent point, you made the point that the second claimant sales, 90% of them were in the UK, which is not surprising as it's a UK company, presumably a UK subsidiary set up for the UK market. But I take it that what is in issue between the parties is a license granted to the first claimant, Vestel, and its subsidiaries around the globe. Is that right?
The claim, if I can break that down, my lord, into two steps. The first is a subject matter of the claim, which is important as I develop my arguments on jurisdiction. And the second is the scope of the relief the FRAND declaration granted. So the subject matter of the claim is the UK standards essential patents. It is our case that on the facts, the FRAND license that would be granted, as in agreed between a notional willing licensor and a willing licensee in all the circumstances of the case, for the licensing of the UK standards essential patents would be a worldwide license. And therefore the declaration would be a declaration which pertains to the worldwide patent portfolio. So in a sense, I'm agreeing with my lord, and in a sense, I think I'm disagreeing with my lord. I'm going to show you the Conversant cases and the Unwired Planet cases in a degree of detail, because it is important that although those cases were ones where a patent was asserted or a series of patents were asserted, whereas this is a negative declaratory relief in effect, in that case, the courts at all levels drew a distinction between the subject matter of the case, that is the rights in issue, the UK standards essential patents, and the interaction with the defence that's provided by the FRAND undertakings that encumber those rights.
Yes, thank you.
Sorry, returning to the procedural context, there were originally 6 grounds of appeal, and there are 3, if I may, 3 classes or types of amendment that are live. I'll start with the amendments. So the first amendment was an application made in front of His Honour Judge Hacon to expressly limit the patents relied upon to the UK standard essential patents. And if I may show my lord and my lady the amendment and the pleading, which is in the core bundle in tab 15, and it's at page 169 of the bundle. So the amendment in front of His Honour Judge Hacon was to insert paragraph 93A. And you'll see that has 2 declarations. One is that the terms of the HEVC Advanced Draft PPL, insofar as they relate to any patents in the patent pool which designate the United Kingdom, are not FRAND. And then alternative declarations of terms which are FRAND for the patents within the pool which designate the United Kingdom. And you can see, I'm afraid you have to slightly read through the strikeouts, but you can see that those correspond to the original declarations at 93 sub 2 and 93 sub 6, except for the insertion of the words insofar as they relate to any patents in the pool which designate the United Kingdom. So there was a debate before His Honour Judge Hacon as to whether our declaratory relief was really directed just at UK patents or more broadly, and that was introduced to make it clear that, at least in the alternative, the declarations were in that narrower sense.
You say in the alternative, but does this amendment not also delete a whole lot of stuff in 93, so that this is all you're left with?
No, so the deletions all come in my second class of amendment, which is the amendment that was made more recently before this court.
Yes, I see. Thank you.
Sorry, I should have clarified that. So there is no formal objection to these amendments. The objection is that they do not cure the defect as a matter of substance. And this amendment was rejected by His Honour Judge Hacon on that ground. I do need permission from this court to make the amendment, but as I said, it's not resisted on formal grounds. The second amendment is the amendment to delete a reasonably significant amount of matter from the particulars of claim and claim form, which we accept cannot be supported in the light of the dropping of the substance of ground 2 of our appeal. That is the application before this court, but it has been granted by the order of Lord Justice Arnold. And if I may show you that, that's in Core tab 23. It's page 218 of the bundle. And it's paragraph 2 of Lord Justice Arnold's order.
Yes. Are you aware of there being any dispute of what the scope of paragraph 2 is? In terms of which bits of your pleading go?
I'm not aware of there being any dispute. So there's a red line provided, and I'm not aware of any dispute that everything in the red line goes.
Yeah. Thank you.
So, Mr. Shaxfield, do you say, therefore, that the reference to the particulars of claim in the claim form in paragraph 3 of that order doesn't do anything?
No, that it does a very small thing relating solely to the claim form, which is my third category of amendment, which I'm about to show my lords and my lady.
So you say it doesn't do anything as far as the particulars of claim is concerned. There's nothing that adds matter, as the judge put it.
Yes, there is nothing new that's introduced by the amendment before, my lords and my lady. It's all just deletion.
So you're taking it as text. You're saying that the difference between para 2 and 3 of the order is just about text. Because I'm bound to tell you it's not how I read the order, but that's what you were saying.
Well, sorry, I'm not sure I quite follow my lord's phraseology of text, but all the deletions that have been made are deletions in my submission that are made in the light of the decision not to pursue ground 2.
Right. So those are the deletions which we find in the draft at tab 15, are they?
I think tab. Yes, that's correct. That is correct, my lord.
As I understand it, Mr. Jackson, what you're saying is, because the only change you're making to the particulars of claim was deletions of text, that means that all those amendments, even if they result in raising new points on appeal, are permitted by the order of Lord Justice Arnold.
I don't believe that they do raise any new points on appeal. And it's my submission that they don't, and I'm going to show my lords and my lady, as it were, the remaining pleading in a moment to show how I base my claim on the pleading that remains unstruck through. I think my Lord Justice Birss may be correct that if, in fact, by the deletion a new argument was created, and it isn't hypothetically possible to delete stuff and make something new, I accept that can be done in a vacuum, then I think that probably would fall within paragraph 3 of Lord Justice Arnold's order, although I haven't identified, and I don't think my learned friends have identified any point where that actually arises.
Okay. My lord, this is a matter of controversy, so obviously we'll address in due course, but we purport to have identified just that.
I thought so. All right.
Well, so my submission, that's my submission, my lord, is that I have permission for these. My learned friend has addressed a particular deletion he says he doesn't like, and obviously I may need to address that once that's been made clear as a controversy between the parties. The third category of amendment, if I may, is that's dealt with in the paragraph 3 of Lord Justice Arnold's order, and that's amendments insofar as they add material which are adjourned to be heard at this hearing. Now, my submission, those are of extremely limited scope and are found in tab 14 of the core bundle. So this is the claim form, and you'll see there are some deletions here, which are what I'm calling these category 2 deletions. That is, deletions of things which we can no longer maintain because of the dropping of ground 2. But there are 2 new additions, which my lords and my lady will see in subparagraphs 2 and 4. Now, these just insert the words insofar as they relate to any patents in the HEVC advance pool, and this is just made to conform the claim form to the amendment which was sought before His Honour Judge Hacon. I can only infer that it was by oversight that the amendments were not made at the time that the particular claim were amended, but I do need permission for these amendments too. But in my submission, if I'm granted permission in respect of the application before His Honour Judge Hacon, then it should also follow that these amendments should be allowed because they are simply a formal conforming of the claim form to the particular claim.
But you accept you need permission from this court to insert the words United Kingdom in the claim form as well as in the amended particulars of claim.
I do accept that.
Thank you.
But as I said, I would stress that the amendment to the particular claim was before His Honour Judge Hacon.
Yes, but rejected by him, which is why you need it from this court.
Yes, I do need permission. It's absolutely correct. I do need permission on category 1 and category 3.
Yes. Lord Justice Arnold's order also referred to grounds of appeal. Do you need any permission to amend the grounds of appeal?
The grounds of appeal are, sorry, I perhaps draw attention to that. The grounds of appeal is just striking through the bulk of ground 2. I can show my lords that if it would assist. It's in tab 2 of the core bundle, and the amendments are at page 12, with a consequential amendment on page 13 and then 14 as well.
And your position is that you already have permission for the grounds of appeal in the version which they appear at tab 2?
Yes, indeed.
Yes, thank you.
If I can now turn to the grounds of appeal, subject to any further questions from my lords and my lady. And I want to identify the grounds and explain how they interact with the amendments. So ground 1 is Gateway 11, property within the jurisdiction, which is relied upon against advance. This was argued before His Honour Judge Hacon and is addressed in the judgment. And the first amendment, that's the amendment to paragraph 93A, and then also to the claim form, is relevant here and for which I need permission. But as I've said, that amendment was one that's resisted only on substantive rather than formal grounds. Ground 2 is now dropped, but this was the ground pertaining to the judge's finding on the evidence about damage in the jurisdiction resulting from abuse of dominant position. Now, this is not pursued as set out in the amendments in my supplemental note that my lords and my lady I hope have seen, but it's the dropping of this ground which has led to the deletion amendments in the particulars of claim and the claim form. And as I've shown you, that is the vast bulk of the amendments, and as I said, that's in respect to those I've had permission from Lord Justice Arnold. The third ground of appeal covers claims relating to the tort of patent infringement in the jurisdiction. That's Article 7.2 and Gateway 9. This is a new legal argument that was not run before His Honour Judge Hacon. But I've been granted permission to run it by Lord Justice Floyd over a year ago in February 2020. And if I can show you that, his order is in Core Bundle tab 12. And that's page 140 of the bundle. And you'll see his decision. The first line of his decision is permission to appeal on grounds refused by the judge is granted. And one of those grounds was obviously ground 3, which is the tort of patent infringement. Now, at the time, or rather in advance of this order being made, the respondents put in the submissions they wish to make under the Practice Direction 52C paragraph 19 rule, and the court ruled against them. This amendment in my submission, this ground in my submission is not affected by the amendments, and I will show you the pleadings very shortly. The ground was covered in Vestel's appeal skeleton argument. It was addressed in both of my learned friends' original respondent skeleton arguments as well. And in my submission, I don't need any further or additional permission to run this point. The 4th, 5th and 6th grounds in my grounds appeal concern gateways 3 and 4A.
Sorry, Mr. Chaxwood, just make sure I don't get in a muddle. Is it right that at the time Justice Floyd gave you that permission, you weren't advancing the amendments to your particulars of claim that you're now advancing to drop the Article 102 case?
That is correct.
Yes. You say that doesn't matter, although I don't think your opponents agree, but that's...
I think both of those are true. I say it doesn't matter, certainly. And then, sorry, I was just addressing my lords and my lady. And the 4th, 5th, and 6th grounds are gateways 3 and 4A, that's the 4th ground, then form convenience, and the 6th ground relates to the amendment which was before His Honour Judge Hacon, and I don't think those raise any separate issues. So, just to summarise, it is my position on this appeal before my lords and my lady that save as regards the paragraph 93 amendments which were before His Honour Judge Hacon, and as I said, not resisted on formal grounds, and for conforming the claim form to that, then I don't need any further permission at all to run the arguments or make the amendments that are before my lords and my lady.
Can I check what you mean by saying the amendment was not opposed on formal grounds? The amendment was opposed and the opposition succeeded on the basis it didn't make any difference to the result. Is that...
Yes, that's right. If I can show, I can take you that. It's paragraph 115 of the judgment, which is in tab 9, and page 130 of the bundle.
Yes, but I see what he says there. He says the same as you've said, but I'm not sure I understand what an objection on formal grounds means.
Okay, I think what the judge has in mind, and certainly what I have in mind, is there's no objection that the amendment shouldn't be allowed because it's too late or causes prejudice or any ground like that. It's just that the objection... So that's what he means by a formal ground. What the judge just says is he's not going to allow it because there's no reasonable prospect of success in respect to the amendment. It doesn't help.
It doesn't change. It doesn't help. Yes.
Yeah.
Thank you.
So I was proposing now to turn on to my second major topic, or second major heading, which is the parties and a brief introduction to the background. This is another area where it is important to have precision, and I'm not proposing to bombard my lords and my lady with evidence references here, but I can provide references for everything, or anything where that would be of assistance. So the Vestel Group is one of the largest manufacturers of television sets in the world, although the majority of its products are sold under brands which are better known perhaps to my lords and my ladies, such as Toshiba, Hitachi, and Panasonic. Whilst it sells other goods as well, Vestel Group's main product is television sets, which it sells primarily in Europe and Turkey. Its biggest market worldwide for televisions generally, and for HEVC televisions in particular, is in the UK. Vestel Turkey is the parent company of the group and is also responsible for manufacture, but it doesn't make direct sales itself in the UK. As we touched on earlier, Vestel UK is the principal sales and marketing subsidiary in the UK. So that's Vestel UK's 2018 accounts were before His Honour Judge Hacon, and they showed a turnover of £303 million, of which over 90% were sales in the United Kingdom. The action concerns the HEVC standard, which is standard used for video compression, as I'm sure you've picked up, in high definition or 4K televisions. And in practice, any high definition television must be compatible with HEVC. Now, many thousands of patents have been declared as essential to HEVC, and in accordance with the rules of the ITU, that's the International Telecommunications Union, owners of those patents are obliged to grant licenses to persons who wish it on fair, reasonable and non-discriminatory terms. And I'm sure you've seen FRAND as well as the acronym. The first respondent, Advance, manages a pool of patents declared essential to HEVC. And their July 2019 data was before His Honour Judge Hacon. And at that time, the pool contained at least 3,500 patents spread across 365 patent families, and of which 77 comprised European patents, and all of those included a UK designation. Now, Philips is the owner of a portfolio of patents also declared essential to the HEVC standard and which are licensed via the Advanced pool. All of the Philips' patents in the pool designate the UK, but Philips' position is in essence the same as the other pool members, and Philips is sued on its own behalf and in a representative capacity on behalf of all members of the Advanced pool. Now, as I understand it, and certainly this was true below, for the purpose of this application, no point is taken on Philips' role as a representative defendant, although Philips has reserved its right going forwards on that point. Now, there's some very useful, if I may respectfully say so, description of the role of standards and standard-setting organisations and hold-out and hold-up in a passage of the Court of Appeal in Unwired Planet, which, if I may, could I invite my lords and my lady to have a look at. It's in JA2, tab 23, and it's page 772 of the authority, paragraphs 3 to 5. So I think my Lord Justice Birss is speaking on mute.
Quite right. Sorry, just give me that reference again.
It's tab 23.
Right.
It's paragraphs 3 to 5. It's 772 of the judgment numbering. I'm afraid I don't know if anyone has an authorities bundle that's paginated. Mine isn't.
Right.
So it's at the start of the judgment of Lord Justice Kitchen, paragraphs 3 to 5.
Yes.
Thank you. So as is set out there, SSOs can be pro-competitive, particularly where FRAND licenses are available. But this passage also highlights the risk of anti-competitive behaviour, either by hold up, whereby a patent owner seeks to obtain supra-FRAND rates, or hold out, where a licensee basically does their best to avoid having to take a licence at all. Now, on the facts, the first contact between Advance and Vestel was in April 2017, which led to discussions between the parties. Nonetheless, during the course of those negotiations, in August and October 2017, Advance threatened two of Vestel's customers stating that they were infringing the patents in the advanced patent pool and threatening to refer matters to their, that's Vestel, that's Advance's litigation counsel. In January 2018, Advance sent Vestel claim charts for 17 patents, of which there was some evidence at trial that 3 of them were Philips patents. Subsequently, 3 more sets of claim charts were sent, some by Advance, some by Philips, and all of these are pleaded. Only the Advance, the second set of Advance claim charts in the evidence, I should say, but all of those are pleaded. And then in May 2018, Advance threatened Vestel with an injunction. And if I can just show you that, it's the relevant letter is in the supplemental bundle of tab 11. It's tab 11, page 69 of the bundle. And this was one of the exhibits in front of His Honour Judge Hacon. As you'll see, it says, it's been a while since we last spoke. I'm glad to be in contact with you. Today I'm writing to you on behalf of our client, HEVC Advance. Our clients forwarded the email exchange between your company and us. Accordingly, Vestel received numerous detailed claim charts in early 2017. Since then, Vestel has not responded to the substance of these claim charts, and HEVC Advance is left entirely in the dark as regards Vestel's position. We don't necessarily accept all that. Our client thus now asks us for our assistance because of our expertise and experience in standards essential patent litigation, and therefore any further correspondence should be directed to our hands. We hope that you decide to engage in good faith discussions to resolve Vestel's continuous infringement of the patents in the HEV Advance's portfolio. As you know, the European Court of Justice outlined in Bahrain's ZTE case what it means for an infringer to negotiate in good faith. Unreasonable display, especially without proper justification, which Vestel has already committed, is an indication of bad faith. The consequence of such bad faith that Vestel may be liable for an injunction. The parties met several times after that in 2018. It's Vestel's case that Advance has never properly either sought to justify their rates or terms, nor have they ever made an offer other than their standard form PPL. So they have stuck to their guns throughout. Or rather, I should say, they treat their offer as unnegotiable in our submission. The claim was issued in 2019, and Vestel has made with that claim an offer in terms which it contends are friend. And since the issue of the claim, although this is not in the evidence before Mr. Justice Hacon, or not all of it is, we have proposed to submit the issue of an appropriate friend licence to an independent arbitration, but this was rejected by Advance in July 2020. Just before I actually touch upon the debate over the friend terms, an update on the foreign proceedings that you may have seen referred to in the skeletons. In July 2020, so that's well after the hearing for His Honour Judge Hacon, Philips and 2 other advanced licensees known as IP Bridge and then the well-known GE company, or within the company, issued proceedings before the Düsseldorf court for the infringement of German designations of patents in the advanced pool. Initially, Philips and IP Bridge did not seek injunctive relief and delivery up and product recall, although GE did. Also, in July 2020, we issued proceedings in the Dutch courts in The Hague for the resolution of the FRAND issues against Philips, Advance and GE, and IP Bridge were added in August 2020. Subsequently, in September 2020, another Advance member, that's Dolby, filed a complaint for the infringement of a pool patent in the Düsseldorf court, seeking inter alia injunctive relief. Now, all of the advanced pool members are represented by a single German firm, Eisenfuhr Speiser, who are the firm that we just wrote that letter we just looked at, and as we've seen, who also represent Advance. In September of this year, Philips and IP Bridge extended their Dusseldorf complaints now also to seek injunctive relief against my client's delivery up and the recall of products. The Dutch proceedings are expressly brought subject to these proceedings in the sense that it's our position that if this court accepts jurisdiction, then the Dutch proceedings should be stayed for lis pendens. In a not dissimilar position, the advanced parties have applied to stay those proceedings pending the outcome of this appeal as well. And they are also disputing jurisdiction for all the defendants except for Philips. And then lastly, in the German case, we have applied to have the German cases stay pending this court's decision, and also for a stay pending clarification by the Court of Justice of a reference from the German courts as to the proper procedure in FRAND cases in litigation between Nokia and Daimler. I'll mention that very briefly again later, but the case isn't before my lord and my lady. And looking forward, the first oral hearing on the technical cases in Germany is due to take place in September of this year, and the first oral hearing on the FRAND issues is set down for October of this year. And the court may consider the stay issues at the first and or second of these. I think the impression I have is it's somewhat up in the air exactly what will be considered at those hearings. And I understand there's no date has been set for any oral hearing in the Dutch cases yet. Sorry, case yet. Turning, if I may, now to the debate over FRAND, in order to understand this part of the debate, one needs to be aware of the existence of another pool under the HEVC standard, which my lords and my lady may have seen mentioned, which is the MPEG-LA pool. There are actually three pools, and the MPEG-LA pool is the largest of them, and Vestel is licensed under it. My client is licensed under it. The third pool is one called Velos, which appears briefly in the papers but hasn't played a real role in this case. Now, the crux of the dispute over FRAND is that the license rate offered by MPEG-LA is around 20 US dollar cents per unit, whereas the advance rate is $1.33 for a 4K television, so 6 to 7 times higher. And that is despite the fact that the MPEG-LA pool is significantly larger than the advanced pool. The evidence was it contained 485 families, compared, you may recall, to 365 for advance. And furthermore, there's a substantial overlap between the two pools, as a result of which Vestel is already licensed pursuant to its MPEG-LA license. And there was evidence at trial indicating that as of July 2019, this extended to about 81% of the pools the patents in Advance's pool. Nonetheless, we're being told we have to pay the full $1.33. It's my client's case that the MPEG-LA pool is a fair comparator license and that this demonstrates the non-FRAND nature of the advanced license. And obviously we have an additional substantial complaint as to the tying of the patents which were already licensed for under the MPEG-LA pool into the advanced pool. Now, Vestel has made a counter-offer and we've sought to engage Advance and Philips, but Advance refuses to make any offer other than its standard form PPL, as it's called, pool patent license. And the Philips offer is based on the Advance offer, but prorated to Philips's patent holding. It says it owns about 17%, I think, of those patents, and then uplifted by 50%. Now, there's certain other concerns with the advanced license and behaviour, but I won't trouble you with those now. Now, as regards to individual patentees, it is possible, or in theory, it's possible to license the patents from the patentees independently. But that's not practical or commercially viable for two main reasons. First, it's the practice of pool members not to offer licenses on terms which are more attractive to licensees than available through the pool. It would, of course, defeat the object of establishing a pool if pool members were offered terms which are more advantageous than available through the pool itself. And Vestel has contacted a number of members of the HEVC pool, and in each case, either a license has not been offered at all or not been forthcoming, or where a license has been offered, Vestel would have to pay more for those rights than it would pay under the pool. And you've seen how Philips prices its own license. And secondly, there are efficiencies and savings and reduced transaction costs in dealing with a pool administrator, and that underlines why dealing with the individual patentees is not a commercially viable option. And there was a bit of evidence about this. Now, my lords and my lady, that was what I was going to say about the outline facts, unless you had any particular questions, and I was going to turn on to the pleading.
How long have you been supplying HEVC televisions in the UK market?
I'm not sure there's any evidence of going to that, or I know the answer to that, I'm afraid, my lord.
And is it accepted, or is it not accepted, that in doing so you are or are not infringing patents belonging to Philips?
So we accept that there will be valid and infringed patents within the pool. We don't accept they're all valid and infringed by any means, but we accept there will be valid and infringed patents within the pool,
Thank you.
which will be infringed by seven. Now, if I may turn to the pleading, principally, I'm just intending to show my lords and my lady the structure, picking up one or two points of detail as we work through. But given the nature of the procedural debate, I think it is important to my to take you through this. I was proposing to do this by reference to the clean version, which is in core, the core bundle at tab 18. I can do it if my lords and my lady prefer by reference to the strike-through version, which is in tab 15. So really, I'm in your hands on that. Otherwise, I'll start at 18.
But my lords, my lady, in case it helps, I will be taking the court to the strike-through version. I need to go to that version. So in case the court's going to be marking up two versions, that's where I'm going.
I think it probably would be more helpful to look at the strike-through version, because your cases, you already have permission for everything in here which has been deleted.
For the yes, indeed, for the deletions, yeah, indeed.
Yes.
So I'm perfectly happy to. The reason I asked the question as to which you prefer is because I perceive that it may be resistance to do that. It's just that working through a strike-through is often sometimes makes one's eyes go a bit funny as well. So if my lord, my lady, could find that in tab 15 of the core bundle at page 145.
Yes.
Now, by way of, as we're helpful, I'm going to cover quite a few of the earlier paragraphs, but as we go through, I'll be able to take things in bigger chunks. And starting with paragraphs 1 and 2, one doesn't need to read them, but just as a brief skim, you'll see that those introduce the Vestel parties. In paragraphs 3 and 4, the HEVC codec encoding is introduced, and you'll see in the second line of paragraph 3 that this is a standard which is promulgated by the International Telecoms Union, or Telecommunications Union. So we plead the standard setting body there. over the page in paragraph 5, the standards essential patents are declared, and as you see from the third line, it says the owners of such declared SEPs are obliged to grant licenses to such patents on FRAND-RAM terms. Such obligations arise under the rules of the ITU, as well as. So that pleads the FRAND obligation. Paragraph 6 to 10 introduce the HEVCA pool. And you see at paragraph 8 on the second line down, you see that Philips is identified as a pool member.
Can I, just before you leave 5, the obligation arises under the rules of the ITU. That's effectively a contractual obligation.
Yes.
Between each patentee who has declared an SEP and the standard setting organisation.
Yes, that's correct.
It's not a contract to which you, as an implementer, are a party.
Well, that is why I was slightly hesitant when I said yes, because I could see where my lord was going. In the terms of this contract are not before the court and weren't debated in front of His Honour Judge Hacon, and it's common ground between the parties that this isn't a contractual claim.
Yes.
We're not seeking specific performance, for example. In the FRAND cases, there was a debate in front of my Lord Justice Birss at first instance as to whether third parties could enforce the equivalent undertaking given by the ETSI standard setting organisation. And my Lord held that third parties were able to enforce that obligation.
ETSI is based in Paris, and that was a French law doctrine.
Yes, that's correct. That's correct. Whereas I think the ITU is based under Swiss law, and nobody has, that I'm aware of, has investigated whether or not third-party rights are directly enforceable in a similar way to the ETSI undertakings.
But at any rate, you're not here relying on that contract being enforceable by you as a contractual obligation to you.
We are not. No, one could hypothesize a case whereby we had brought an order, essentially a case effectively for specific performance or something along those lines, seeking to enforce a contract in that way. But that is not how this claim has been structured. And as I've said, it's common ground. In fact, my learned friends are very keen to keep stating that this is not a contractual claim in their submissions.
It's complicated enough to understand the claim you have brought, so let's not worry about claims you haven't brought.
Indeed. So sorry, I think I was at paragraph 6 to 10 of the pleading here, which introduced the HEVCA pool, and as I said in paragraph 8, that introduces Philips itself. Over the page on page 148, in paragraphs 10 and 11, you see that MPEG LA is introduced. That's my comparator pool. And then in paragraph 12, the Velos pool makes a brief appearance and then disappears again. Now, turning over to page 14, we set out the relevant dealings between the parties, starting with Vestel and HEVC Advance. And my lords and my lady will see in paragraph 15 that we plead the injunction threat, which I showed you a few minutes ago. Now, this carries on. I don't think one needs to worry about this detail down to paragraph 25 on page 151 of the bundle. Here we set out contact between Vestel and Philips, and on page 27 overleaf, you see the nature of the Philips license is described, and that is set by uplifting its share of the advanced pool license, as I explained to my lords and my lady earlier. We then come to the objections being set out, and in paragraph 28 you'll see that the claimant objects to the terms not being FRAND, and we say that that's true of the terms individually and in combination. And then we set out over a number of pages further detail. Starting at under paragraph 29, you see the rates, and if one turns over, you see that we set out our comparator being the MPEG-LA patent pool license, as I've outlined to my lord and my lady already. Now, for there, one can skip forward to page 155, where you see above paragraph 39 that we plead matters relating to the structure of the license. And then overleaf, you see other onerous and unreasonable terms. And then 2 pages further on, we have a section, that's page 158 of the bundle, other objectionable conduct and failure to comply with FRAND as a process. And if I could draw your attention particularly to paragraph 51, which says, further, as already pleaded above, from an early stage in negotiations between the parties, HEVC Advance has unjustifiably been threatening Vestel with injunction proceedings. The aforesaid threat, coupled with demand for license terms which are unfrand, constitutes a form of or attempt at illegitimate hold-up. So that's another pleading of the injunction threat and hold-up. We then plead Vestel's objections to Phillips's terms, and in particular, if I can draw your attention to 54, where we say the 50% uplift applied by Phillips is unjustified, is not FRAND, and then for the avoidance of doubt, Vestel will say in any event that the per patent rate based on the HEV advanced pool would not be FRAND for the reasons given in relation to the HEV advanced offer that we've already seen. That then takes us to pleading our counter offer. And if I can draw your attention to paragraphs 66 and 67 on page 161 of the bundle. So we say further in the alternative, if we deny the rates or other terms of Vestel offer and not FRAND, Vestel will say the Vestel offer was a reasonable counter offer to make based on information based on it. Furthermore, Vestel is and remains willing to negotiate with HEVC Advance and will adjust its offer. Finally, if or to the extent the parties cannot agree as to what FRAND terms are for the pool, Vestel is prepared to take a license to the HEVC Advance pool in whatever terms this court determines to be FRAND. So we plead our willingness to take the FRAND license determined by the court. There is then a section on abuse of dominance. You see there's significant strikings out. If I could ask my lords and my lady to look at paragraph 74, which pleads why in practice it's not commercially viable to take licenses through the individual patentees. This was supported by a little evidence in Mr. Moss's first witness statement on the application to serve out as well. And then paragraph 77 builds on that slightly.
You told us that a large number of the patents in the advanced pool were also in the MPEG pool.
Yes.
Are they different patentees? Is it 80% of the patentees are in the MPEG pool, or is it for a particular patentee, such as Philips, some of its patents are within one pool and some in the other?
Well, it's more to do with individual patentees. So there are two that appear in the evidence, Samsung and one called Etri. And Samsung and Etri, and this, I think this may be true for others, but certainly those are the main ones focused on. They are members of both pools, and all of their patents fall within both pools. So if one takes an individual, or indeed every individual patent license that we have a license to already under the MPEG-LA pool, those patents also appear in the advanced pool, and advanced say we have to take a license for them in respect of those patents as well. So we would then be double licensed for a single patent, and obviously that is something we object to.
But you wouldn't be double licensed if you took the patentees who are within the MPEG pool and you didn't seek individual licenses from them anymore and simply sought individual licenses from those patentees which are not in the MPEG pool but are in the advanced pool.
I think that is correct. I think that is correct. But but one of the points is this evidence here is is put forward. So the pleading here is put forward to indicate that actually it's not a commercially viable or appropriate way to go forward to have to negotiate individually with each patentee. And indeed, it doesn't really lie in the mouth of a patent pool to say we're going to offer standard terms which require you to go to the individual patentees. It's also more expensive as well to go through that, because you've seen, as I've shown you earlier, that the way that the patentees price their portfolios, they say, well, we'll take the advance rate, and since it's coming to us directly, we're going to uplift it. And you've seen how Philips charge.
Yes, that wasn't my point. My point was you could avoid double licensing by only going to the patentees who were in the advanced pool but weren't in the MPEG pool. Suppose that was just Philips for the sake of argument. So all your other patents you've already got from the MPEG pool. Philips you would have to pay, as you say, 50% over the apportioned rate. But it wouldn't mean that the total you would have to pay would necessarily be as much as the total advance royalty rate. That would all depend on the figures, and it might be that the apportioned part, the advance royalty which you paid Philips, would not be a very significant addition to what you were paying under the MPEG pool. We simply don't know.
I don't think that maths has been done. I think that's correct. That's correct. But what we do have evidence is that going to there's significantly increased transactional costs in going to each of the individual patent pool proprietors. Plus, they also charge a rate per patent, which is higher than you get through the pool. And so it's. But my lord is right. We don't actually. Nobody's actually crunched the numbers.
Yes. Thank you.
I was just referring to 77, which is on, I think, essentially the same point. My lords and my lady may have had a chance to look at that. And after that, if I could ask you to look at paragraphs 85 to 88, which start at page 166 of the bundle. This pleads the relationships between the parties and also the representative claim. And then finally, that takes us to the relief, which my lords and my lady have already seen, which is on page 169. And you have three declarations, one of them at the top of the page, which is the tail end of paragraph 93, and then you've got 93A. So those are the three declarations sought, and you've seen those.
Where do we find, I'm sorry to be next to you about this, where do we find the current state of the declarations that you seek for which you already have permission?
The current state of the declarations, I see. So the claim form is probably okay. So sorry, my lord, let me break that down. So just looking at the page 169 of the bundle, there are the three declarations we seek are set out there, which is, you see at the second paragraph down, is 93.5, which is the terms of our counteroffer of FRAND, And then we obviously don't need any type of permission for because that was in the original pleading. Then you have 93A 1 and 2, and these are the Category 1 amendments that I've called them, the ones before His Honour Judge Hacon, and I do need permission for those, but they are in no sense new amendments. They were before the first instance judge.
But you have not yet got permission for them. So what is the current state of the pleading, which sets out the terms of the declarations for which you already have or don't need permission? See that it includes 93.5, which was always there, but in place of 93A 1 and 2 in their current, as they appear here, these are unpermitted as they appear here.
That is correct.
Where do we find what they replace?
Well, I think the answer to that, if I can take it in, I think it's 2 stages, my lord. You see what they were developments of. If one looks at 93 subparagraph 2, which is struck through, then 93A1 is a development of 93.2, but with insertion explicitly limiting the declaration to the UK patents. And 93.6 is the original declaration to which the limitation to the UK standards essential patents has been added in 93.2. We don't have in the bundles, I'm afraid, and yet another version of the pleading which unpicks all of this going back to the very original. That can, of course, be provided if that would give assistance to my lords and my lady.
No, I'm not sure that that's what I would like. What I would like to see, we're being asked to grant permission for what is now in 93A little 1 and little 2, because His Honour Judge Hacon refused to do it, declined to do it. So what I would like to see is what the form of those declarations currently is, which we're being asked to grant you permission to amend. We can see the form in which you want to amend them, but we can't see the form in which they currently stand.
Yes. So 90 years. Sorry. Yes, indeed. So I'm afraid yes, you don't have that. The form in which 93A was just an insertion into the pleading, and it's so before His Honour Judge Hacon, we were seeking both the declarations in form of 93 subparagraph 2 and 93 subparagraph 6, and then in the alternative, the narrower declarations in 93A.
So it is 93 little 2 and 93 little 6, which 93A replaces.
I think that's right.
Thank you.
Just to make sure I've understood what you're doing, Mr. Chacksfield, you've now dropped 93 little 2 and little 6 anyway.
Yes, that is correct.
So if we were to refuse you permission to make the amendments that are 93A, you don't go back to 93, 2 and 6 because they've gone as well. And you say you've got permission to drop them and you're dropping them.
That is correct. At that point, then the only declaration that would be being advanced would be the declaration in 93.5, which is that the terms of the offer are frowned.
Yeah.
Thank you. Well, I think that's clear. I hope so.
I apologise. So as you see, we've pleaded, and as I've shown you, we've pleaded the parties, we've pleaded the patent pool, including the UK SCPs within it. We've pleaded the ITU friend obligation. We've pleaded the dispute between the parties and the injunction threat. We've pleaded Advance's threat of hold-up. We've pleaded the problems with Advance and Philips's license and why our licenses, we say, frowned. And we've pleaded the alternative that we would take a court-declared frowned license, and I've shown you the claim for relief. Now, as I said in my introduction, other than the paragraph 93A relief, which we've just been discussing, all of this is from the original pleading. And in my submission, there is nothing new here. I was going to move on to two other pleading points on, but before I leave the particular claim, are there any other issues you'd like me to address you on at this point?
Do we need to pay any attention to your final paragraph, which is the one about joining the first claimant, which is the putative licensee? First claimant doesn't do anything in this country, as I understand it.
I think that's correct on the evidence.
Does that cause any problems for you, that you're seeking relief in the form of a license, or rather declarations as to the terms of a license, to be granted to Vestel in respect of acts which are being carried out by Vestel UK? And Vestel UK is not itself seeking a license. Is that something that...
Well, it's actually a very common approach in these cases, as was adopted in Conversant and in Unwired Planet and in all the ongoing cases as well, whereby the party which in reality is the one that would sign licenses on behalf of the group is joined to the case, such that all relevant and necessary parties are before the court. My learned friends don't take a point on the presence of the first claimant in this case. And as I said, it is the common approach in this kind of FRAND action.
Okay, thank you.
So if I may pick up on two final pleading points. The first is a response to a Part 18 request, which we provided to Advance, which is in tab 4 of the supplemental bundle. It's at page 15 of the bundle. And there's, under request 21, it was said, is it the claimant's case that such declaratory relief is a proper form of relief for cause of action based on competition law, to paraphrase? If so, please explain the basis. If not, please explain what is intended basis. And the reply says that it is our case that declaratory relief sought is relief for cause of action based on Article 102 TFEU, etc. But then in the important second paragraph, it says, further or in the alternative, the claimants will say that relief sought will resolve outstanding commercial issues between the parties, provide commercial certainty, and as such is subject to the court's inherent jurisdiction. So, as regard Advance, declarations based on the court's inherent jurisdiction were pleaded before His Honour Judge Hacon. Now, the position is different as regards Phillips, and if I could invite my lords and my lady to turn back one tab to tab 3 and look at request 4 on page 8. So my learned friend, Mr. Pickford, relies upon this, and he does so because it does not say, and I accept it does not say, that the inherent jurisdiction is relied upon against him, but it says the claim is based on the abuse of dominant position. Now he relies upon this to say I should not have permission to run any other arguments. And there is in the bundles, and I can show you, there is some bundles about law about text for changing permission. But my primary position is that I have permission to run the arguments based on the tort of patent infringement from Lord Justice Floyd from a year ago, and that I was given that permission in the light, or despite, as it were, the respondent's CPR 52C paragraph 19 submissions. If it comes to it, I will also, when I understand what it is, how it is my learned friend is developing his case on this, this is just one of those changes which is a new legal analysis of old facts, and there's no evidence or suggestion of prejudice to respondents, but I'll develop that for my own response once I actually know how my learned friend is really advancing this.
Yes.
With that, I believe I can turn to the substance of the appeal.
Before you do that, is it time for a break for the transcribers?
I'm sure that's...
Yes. Yes, it is. It's now 11:50, so we'll say 12 noon. Incidentally, I'm not receiving, I don't know if any members of the court are a live transcript. I don't know if other people are getting a live transcript. And I don't know if any arrangements have been made for us to receive it. It doesn't particularly matter because I'm taking notes anyway. And no doubt we will, I assume, be getting the transcript at the end of the day.
My lord, my apologies. I have the advantage of a live transcript. I'm not sure why my lord, my lady don't have one. That seems, I can only imagine that that's an oversight. I will talk to my instructing solicitors in the next 10 minutes, and hopefully that can be rectified extremely quickly.
As I say, it's not proving a serious impediment at the moment, but if it's there, it's nice to have it. It's 12 o'clock. Yes, Mr. Traxfield. Speaking for myself, I now have the transcript. Thank you.
Good, good. I'm pleased.
I don't know if my lady and my lord also have it.
Yep.
Good. Yes.
Well, I apologise you didn't have that this morning. So, Gateway 11. The test to be applied is that in Brownlee, maybe there has to be a good arguable case that one of the gateways applies. There has to be reasonable prospect of success to the claim applying the summary judgment test, and England has to be the proper place to bring the claim within CPR 637.3. The applicable test under the first limb can become complicated, but as I'm sure you're aware, is summarised in paragraph 7 of Brownlee as that the claimant must supply a plausible evidential basis for the application of the relevant jurisdictional gateway, or second, if there is an issue of fact about it or some other reason for doubting whether it applies, the court must take a view on the material. It can reliably do so. But 3, the nature of the issue and the limitations of the material available at the interlocutory stage may be such that no reliable assessment can be made, in which case there's a good arguable case for the application of the gateway if there's a plausible but contested evidential basis for it. I don't really think there's going to be a big debate about the test in this case, but I would draw 4 conclusions from that, which are really based on the Kiefer decision. Which is referred to in the judgment at 81. But the 4 propositions are that this is a context-specific and flexible test, which requires the claimant to show that it's has the better case relatively. But it isn't a test on the balance of probabilities, and that reflects the nature of the interlocutory stage and the evidence which may be before the court. Third, that under Limb 2, in particular, this may include the use of, to quote, judicial common sense and pragmatism to overcome gaps in the evidence. And lastly, where there are effectively insoluble conundrums, then under the third limb, the court adopts a test which in effect asks whether the claimant has a good arguable case supported by evidence which is plausible even though it's contested. And so on this test, therefore, this is different in that it's not conditional on the relative merits, but has regards only or principally to the claimant's case. So the substance of Gateway 11, this applies, as is familiar, to where the subject matter of the claim relates wholly and principally to property within the jurisdiction. And just for your note, that's the gateways are in Joint Authorities 1 tab 3. This was an argument developed before His Honour Judge Hacon, and I've shown the pleadings and the Part 18 request relating to it. If I can show you how it was put in the evidence for the application to serve out. This is in Mr. Moss's first statement in Supplemental Bundle tab 5, page, well, there's 2 sections. The first is at page 23. And if I could ask my lords and my lady just to read paragraph 24b. And then going over to page 26, you'll find paragraphs 30, D and E. So 30 says the claims relate inter alia to property situated in the jurisdiction, namely the patents which designate the UK. And then E, there is an extant clearly defined and commercially real dispute between the claims and the first defendant as to the FRAN terms on which they're entitled to license the patents to avoid infringement. And just to show you one other, if I may, reference, it's in tab 16, which is Mr. Ayrton's witness statement. This is Advance's solicitor. Tab 16, page 105 of the bundle. And in paragraph 9, he's summarising the basis upon which we put the case. But he says in 9b, the declarations as to the licensing terms sought by Vestel relate to property within the UK in the form of UK patents within the HEVCA pool Gateway 11. So there's no doubt this was a basis which was advanced on service out, and it tracks through into the skeleton arguments, which I'm not trouble you with, but I will show you his judgment. In fact, we looked at 150 in his judgment recently. Now, in summary, my case on this gateway is very simple indeed. There are three propositions. The first is that UK patents, and that includes European patents designated in the UK and applications for them, are property under English law. The second is that Vestel seeks a declaration in respect of that property. And the third is that the declaration sought is the FRAN terms which pertain to that property. And of those, our case, the FRAN terms are worldwide. That does not make the property, which is the subject matter of the claim, anything more than entirely situated in the jurisdiction. The argument to the contrary, which found favour with the judge, confuses the property which is the subject of the claim with the FRAN licensing terms in respect of that property. And it's wrong in my submission for the same reasons as the arguments of the implementers in Unwired Planet and Conversant were wrong, and I'll show you those shortly. There is, as I understand it, no dispute that European Patents UK are property within the jurisdiction. For your note, this was addressed by Mr. Justice Henry Carr in Conversant at First Instance, which is in JA 221 at 108 to 110. And also for your note, I've included the relevant sections of the Act in JA1 tab 1, and it is sections 30, 77 and 78 as sidelined. Now, where the main debate arises on this appeal, as it did before His Honour Judge Hacon, is as to whether the property is wholly or principally within the jurisdiction. And I can start with the judgment, which we did look at earlier. It's core tab 9 and page 129. So, paragraph 110 deals with the fact that a European patent is UK property, and as I said, that doesn't seem to be contested. 111 to 113 pursue the wider case about declarations relating to all patents in the pool. I'm not sure that really ever was the focus of our case, certainly not as set out in Mr. Moss's evidence, but in any event, that's not pursued on this appeal. And then what matters is 114 and 115. So this is the argument which is pursued on appeal. And we've already looked at the first sentence dealing with the objection on substantive rather than formal grounds. Now, in the remainder of the paragraph, in my submission, the judge made, in particular, two major mistakes. In the second, third, fourth, and fifth lines of the paragraph, he makes a number of related statements relating to the fact that none of the existing pleading would be deleted, he says, and that the amendment was, at the time, sought in the alternative. And he appears to go on, based on that, to hold that claims relate to patents throughout the world. Now, that is, in my respectful submission, to completely misunderstand the process. It was only because the judge had rejected the wider claim that the narrow claim would need to be considered. And as a result of his objection of the wider claim, that wider claim would necessarily have to be struck out. So this represents really confused thinking. And in any event, we've struck out and abandoned or no longer pursuing the wider declaration in any event. And you've seen that in the struck-through paragraphs we looked at a few minutes ago. Now, the other and much more important...
Mr. Chancellor, did you say that to the judge, that he needed to consider 93A on the basis he'd struck out bits which he says were not struck out?
It wasn't me, my lord, at all. But certainly in this oral submissions below and in the skeleton argument below, and I can show you if it assists, the point was made that it was said by the then defendants, now respondents, that the declaratory relief related to all patents throughout the world, of which only a relatively small proportion were EPUKs. And in order to address that, for the avoidance of doubt, the amendment was made to limit the...
I understand. You said that. It may not matter.
I'm not sure it does matter, my lord, because certainly they are struck out now.
Yes.
The fundamental error the judge made, in my respectful submission, was that he misunderstood the nature of the claim, and this is the Unwired Planet and Conversant point. This is a claim for a court determination of the appropriate FRAND licenses for the UK SEPs. If it turns out the appropriate FRAND license for the UK SEPs is a worldwide license, that doesn't change the nature of the claim. That just means that those are the terms upon which the UK SEPs can be licensed. The judge confused the subject matter of the claim and the relief and fell into error in effectively accepting the submissions that have been shown to be wrong in both Unwired Planet and Conversant. Now I can start with Unwired Planet, which is in JA2 at tab 23. Now, this was a case in which it was submitted on appeal that my Lord Justice Birss had erred at first instance in determining the scope of a worldwide FRAND licence on the basis that this exceeded the scope of the court's jurisdiction, which was to deal only with UK patents. And the Court of Appeal held that this argument represented confused thinking, and in my submission is exactly the same error as the judge fell into this case. Now, if I could ask my Lord and my Lady to read paragraphs 75 to 81 of the judgment, starting on page 788. So in 77, you see in the fourth to fifth lines, it summarises the gravamen of the complaint. It was said that my Lord Justice Birss' decision amounted to an indirect interference with foreign litigation relating to foreign property. But in 79 to 81, the court dismissed that argument. In 81, about halfway through the paragraph, the court says, in doing so, he, that's my Lord Justice Birss, was not adjudicating on issues of infringement or validity concerning any foreign SEPs, nor was he deciding on what the appropriate relief for infringement of any foreign SEPs might be. He was simply determining the terms of a licence that UP was required to offer Huawei pursuant to its undertaking to EWCA. Now, if I may also ask my lord and my lady to read what is a fairly long passage from 52 to 58, which starts on page 781 of the internal numbering for the judgment. So going back to 57, it's addressing a scenario where if on the facts a national licence were to be frowned, or rather put it another way, if on the facts a national licence were to be frowned in our present case, then of course no question of extraterritorial effect arises at all, and advanced objection never gets off the ground. But if one takes the scenario considered in paragraph 58, where the court is considering global frown licences, well, here the Court of Appeal draws a distinction between the UK SEPs which underpin the cause of action and the FRAND undertaking which is relevant to the relief obtainable in respect of those UK patents. And you also see the Court specifically rejects that this would involve any type of jurisdictional expansionism. You see that about 8 lines from the end of paragraph 58, which is an argument which the respondents seek to resurrect in this case. Now, Unwired Planet was not a case concerning a jurisdictional dispute under CPR 11 proper, although it's very closely related. But the same approach was adopted in that context in the Conversant litigation. Now, the Conversant litigation was one in which the defendants contested jurisdiction, relying heavily on the fact that only 1% of Huawei sales and 0.07% of ZTE sales were in the UK. Yet the FRAND licence sought by Conversant was pleaded as being global. The first instance judgment is at tab 21 of JA2. And if I could invite my lords and my lady to read paragraphs 65 to 70, where Mr. Justice Henry Carr is addressing the defendant's central argument. This is page 645 of the judgment.
Yes.
So, as you've seen in 66, Mr. Justice Henry Carr accepts that these claims are for infringement of UK patents, and that is a matter of substance, not form. And he goes on to distinguish this from the object of the proceedings in terms of the relief sought. Now, this was addressed in the appeal judgment, which is in tab 24 of this bundle, from paragraph 95. That's at page 112 of the internally to the judgment. So 95 just is really introduction. At 98, the court summarises one of the passages from Unwired Planet, which we have just looked at. And then at 99, the court says, Conversant's claim in the present case is closely analogous to the claim advanced in Unwired Planet. It is one that the UK patents are essential to the standard, two that is complied with its ETSI undertaking, in that the offers which it has made are FRAND, three that Huawei and ZTE have not so complied without any reasonable grounds for doing so, and four, there's not entitled, it's therefore entitled to enforce the UK steps without, and to obtain, usual relief injunction, including a FRAND injunction damages. Conversant also seeks a determination as to the terms which are FRAND for its licensing of its portfolio. Huawei and ZTE's answer like to be that Conversant's patents are neither valid nor essential, and the Conversant has not complied with FRAND undertaking, so it's not entitled to an injunction. Then it says the content of Conversant's FRAND undertaking is thus an inseparable part of a dispute about whether Conversant is entitled to relief from the infringement of valid UK patents. And one can then skip down, I think, to the end, where the court says it's also not legitimate to characterise the claim as one for enforcement of a global portfolio right. No such right exists, as this court readily accepts in Unwired CA. I therefore rejected appellant's challenge the way in which the dispute is to be characterised. The question which the judge asked himself was the correct one, and we've just seen that. So in my submission, in both of these cases, the logic of the court has been, first, that the claim is in respect of UK SEPs, and those, as Conversant confirms, are property within the jurisdiction. Second, the question of the FRAND undertaking is an inseparable part of the dispute about whether the patentee is entitled to relief from infringement of a valid UK patent right. And third is that on the facts, relief may prove to be a global licence, but that does not enlarge the scope of the claim brought, and nor is it jurisdictional expansionism. It's just a consequence of the interaction between the global nature of the FRAND undertaking, given, with the local nature of the patent rights in issue. And to that, I would add a fourth point, which is that although these present proceedings, so whether those cases involved actions brought by a patentee, it makes, in my submission, no difference in logic or principle that the claim here is for declaratory relief brought by an implementer. The subject matter of the claim remains to relate to the UK SEPs, and the scope of the declared licence is a matter for relief. As a question of what relief should be granted, having regards to the scope of the FRAND declaration upon all the facts then before the court. Now, in my submission, His Honour Judge Hacon was therefore wrong to reject the claim as falling within Gateway 11. The right analysis is that the claim relates, and indeed only relates, to UK standards essential patents, and so falls within that gateway. And if I'm right on that, then in my submission, permission to make the paragraph 93 amendment and to conform the claim form in the way we've discussed should also be granted. Now, in paragraph 37 of his appeal skeleton argument, my learned friend Mr. Segan raises under the gateway head the question of whether the declaration sought serves no useful purpose, but I'm going to address that under reasonable prospects of success rather than the gateway. Now, subject to any questions from my lord or my lady, those are my submissions on Gateway 11.
I I have a question, Mr. Shaxfield. What legal right do you have to claim the relief you're seeking, which you rely on for Gateway 11?
What legal right? Well, I'm seeking a declaration here in respect of property within the jurisdiction. You don't need a legal right, as in a cause of action, to seek declaratory relief. And I'll come on to show you that later on, because it's a point that is taken.
So you're not relying on having a cause of action to justify the relief you're claiming from the court. You say you don't need one.
I say I don't need a freestanding cause of action. I'm bringing this claim before the court to seek declaratory relief. And the case that I'm going to refer to is the decision of my Lord Justice Birss in Pfizer and Roche. And you may recall in that case, that was an Arrow Declaration case. And I'm going to submit the Arrow Declarations are informative. And there was a major, possibly the major part of the dispute in that case is whether the court can grant declaratory relief where there was no cause of action, there was no patent right in the UK. Indeed, there would never be a patent right in the UK. And my Lord quite correctly held that you don't need that. It's just a question of the exercise of the judicial discretion as to whether or not you grant relief.
What legal standard is the court being asked to apply in deciding whether you are entitled to what you call a FRAND license?
Sorry, to determine the terms of the FRAND license, this is something, again, I will address you on, but the determination of the terms of the FRAND license will require the court to consider, having regard to the provisions of the FRAND undertaking given by the International Telecommunications Union, what a willing licensor and willing licensee would have agreed in all the facts of the case. In the same way as in Unwired Planet, that's how it's put by the Court of Appeal. I can show you, my Lord, how the Court of Appeal puts it, that would help.
Well, the reason I asked the question related to the way I've asked you the question but previous to it is that you're now talking about the undertaking to the ITU, but you're not relying on that undertaking as being legally enforceable. So I don't understand why, I'll tell you now, why you say that it's relevant in answering the question I asked you. Well,
it's relevant because if my learned friend was to seek to enforce UK patents against me, then in the normal run of things, I would be able to rely upon the FRAND undertaking given to the ITU under Article 102, irrespective of a contractual right, to say that he cannot bring those claims, he cannot bring that claim against me without offering me a FRAND license. The FRAND license then is that which is defined insofar as it's defined or rises out of the ITU rules, but that's not a contractual claim. That's an abuse of dominance claim, and that's essentially that's how it's considered in Huawei and ZTE in front of the Court of Justice.
But you dropped your abuse of dominance claim, Mr. Shaxfield.
I dropped an abuse of dominance claim brought on the pleaded basis, which was that their offers were so far off FRAND that amounted to excessive pricing, and that causes damages in the jurisdictions. This is a different claim, which is if they seek to assert patent rights against me without offering me a FRAND license, that would be an abuse of dominance.
That's not the claim you're making in this case either, though, is it? I don't recall reading that in your particulars of claim.
Well, they have threatened. No, this is the question which goes to the point that, as I see it, that my Lord is raising, goes to the question of useful purpose, which comes under the second question as to whether or not the claims have a real prospect of success. They have asserted a patent portfolio against us, including UK patent rights. They've never given us undertakings, they're never going to sue us in respect of the UK patent rights. We seek declaratory relief as to a defence that would arise in respect of those patent rights if they were asserted against us, in the same way that an Arrow Declaration seeks to establish a preemptive defence against a patent claim that could be asserted against the defendant, the implementer in the future. The basis for that defence is that we're entitled to a FRAND license before they can assert their patent against us. And that's not based on a contractual claim we bring. That's based on the fact that qua NZTE, as a matter of competition law, says they have to make us a FRAND offer in advance. And we are trying to preemptively determine the scope of that FRAND license.
Well, you're going to tell us about, you say you're going to deal with this at the point where you deal with useful purpose. I'm not trying to take you out of your course, but you can tell from the way I'm asking the question that I'm puzzled by the fact that you don't appear to have or to be bringing a claim in law at all.
If I may address it in the context of useful purpose, then I will go on to address this, my lord, certainly.
Right.
I'm just thinking. In fact, my lord, why don't I jump ahead and go and do that now? I'll move on to you. I can address no serious issues to be tried now, and then come back to the other heads after. So the question of serious issues to be tried, the question here is whether the claim for declaratory relief is sufficiently arguable to pass the summary judgment test. At trial, the grant of declaratory relief will be a question of discretion having regard to all the circumstances, including the FSA and Rourke factors of justice to the claimant, justice to the defendant, useful purpose, and any other special factors for or against the giving of declaratory relief. Now, sorry, did I talk across them?
No.
Now, given that the grant of declaratory relief is so dependent on the facts at trial and the exercise of judicial discretion, in my submission it's quite an unpromising field in which to effectively obtain summary judgment. In any event, it's my submission that the Vestel case will readily and obviously pass this test, and we will make 7 points in respect of that. The first is that the UK is Vestel Group's largest market for relevant televisions worldwide. Secondly, as regards the second claim, that the UK is its primary market, accounting for in excess of 90% of its 300 million odd turnover. Third, we rely upon the fact that there are at least 77 patent families in the advanced portfolio which designate the UK. Fourth, at the time of the application to serve out, Vestel had been threatened with litigation under the advanced patent portfolio, including with the seeking of injunctive relief, although at that time no proceedings had been brought. Fifthly, the declarations would inform Vestel generally and Vestel UK specifically of its exposure at a minimum under the UK SEPs. Sixth, the declaration sought would also provide a bar or at least a serious limitation to any action subsequently brought to assert any of the UK SEPs. Now, as I've said previously, our primary case is that any such claim would be barred as an abuse or under Article 102. But in any event, the declaration would serve to prevent the grant of relief, any relief, or alternatively injunctive relief. I also mentioned in my introduction that the specific terms of the pool licence between Advance and its members serve to underline this. And can I show those, my lords and my lady, now? These are found in the confidential bundle at tab 2. And on the first page of the tabs, page 2 of the bundle, you can find clause 4.1. This is a clause addressed to the conduct of litigation generally involving the pool. And I won't read it out, given its confidentiality, but if I can invite you to read the first sentence, which runs for about 10 or 11 lines, with particular focus on the A scenario.
When you say the A scenario, what you mean is when it says in the event that, and then there's an A.
Yes, indeed. Yeah. But if the court were to determine Fran terms, then unless they have been offered to Vestel, and we've said we will take them, then it seems extremely hard to see how this provision could ever be satisfied as regards advance. And as a consequence, they can't propose enforcement action against us. B, the little b, relates to bilateral licenses and is less relevant. And then if I could invite you to read the sentence starting each licensor, which follows on, which is just next to the top hole punch, which runs to about 6 lines, 5 lines. So this sentence relates to individual patentees, and the effect of it is that in my submission in the court, if the court declares a Fran terms, but they are not offered to us, then no individual patentee will be able to sue us either.
I'm sure it's just me, but I'm using the Elektronik bundle, so the hole punch doesn't help. I have not found the sentence you're talking about that begins with the word each in this mass of text.
Okay, my lord. The first sentence ran down to the bolded word action, about 10 lines down. There's a second sentence.
Found it. Thank you.
Excellent, thank you.
This is what? This is a contract between each of the patentees in the pool and Advance as the administrator of the pool.
Now, obviously, we're not privy to this contract.
This is what, an American contract?
I'm not sure we have the terms, but one might be able to infer that, certainly.
I mean, Advance is based in Delaware, I think? Yeah. And it certainly looks from its style to have a sort of American style of drafting.
Yeah.
But you're not suggesting that you have a contractual right to rely on that. So would that amount to a defence to an action for patent infringement?
It doesn't, no. So I'm not suggesting that we're privy to this agreement, my lord. That's what I was about to say. I'm definitely not suggesting that. But what I am going to say is that unless my learned friend Mr. Segan's case is going to be that the pool or the individual patentees within the pool are going to go forward in breach of their obligations under this to each other and to the pool, then this is an additional benefit the declarations would bring, because in practice, if the declaration is made as to Fran terms and is not offered to us, then they would be in breach of these terms towards each other in bringing a claim against us. And I say I can legitimately rely upon that, even though I don't have a cause of action against them, because I completely accept we're not a party to this agreement.
It wouldn't give you any legal rights.
No.
But you say commercially it might be valuable because it might act as a practical constraint on the patentee suing you, even though if they did sue you, there's nothing you could do about it.
I think that's right. But to put it the other way around, for my learned friend's case, he would have to say this court should assume that the pool or patentees within it will act in breach of obligations which they've agreed between themselves. But my lord is absolutely right. I'm not suggesting that this gives us a contractual defence to any claim brought. That is absolutely correct. It is a commercial practical impediment. So that was the 6th of my submissions as to the use, the fact that the declaration is arguably to be granted by the court. The 7th is the one that has been referred to as spin-off value. And if I may explain this term by reference to my Lord Justice Birss's judgment in Pfizer and Roche. This is in J2 tab 25, and it's page 395 of the judgment. And if I can invite my lords and my ladies to read paragraphs 83 and 84. So my Lord Justice Birss held there, and we submit entirely correctly, that spin-off, that is the use in other EPC jurisdictions, can be very valuable, and it is legitimate to rely upon it, especially in a case which has connection to this jurisdiction, as we submit it does here. Now, spin-off is only one aspect of Vestel's case, but it is a legitimate point, and we do rely upon it. It is true that Vestel hopes that a decision here will resolve the worldwide FRAND license terms, not just the worldwide FRAND terms, just as in Unwired Planet and Conversant, they hoped it would in their cases. But we submit there's no criticism in that. Now, if I can turn to points raised by my learned friend, Mr. Segan, one of which touches upon the question my Lord Justice Birss asked me. Advance's position is summarised in their skeleton at paragraph 6.2, which is core 7, page 60. So it's paragraph 6.2, page 60. They say, first, there's no identifiable or justiciable legal standard by which to judge the claim. Second, it said there's no useful purpose, but I've already addressed you on useful purpose, and I don't propose to repeat that. So it's page 60, paragraph 6.2.
Yes.
Third, there's a point on the TQ Delta case and what they call jurisdictional imperialism. And to these I would add two more points. There's a fourth point which is softly advanced in paragraph 13, about halfway through paragraph 13. It said that Advance does not have authority to grant any license that is materially different from the PPL, which is their standard form license. And that's cross-referred to at the end of his paragraph 37, which is at the top of page 71. And the fifth point is set out in paragraph 45 of their appeal skeleton. This is at the point where it said the courts only grant declarations which are concerned with legal rights, public and private, referring to Pfizer at 74 to 75. And so this raises the question of whether one needs a legal right in order to seek declaratory relief. Dealing with the first and third to fifth of these. The first I've already touched upon in response to a question by my Lord Justice Birss, which is, is the court, in my submission, plainly can assess friend terms, and indeed has done so. Although we do not rely in this case upon the enforcement of the contractual obligation to the ITU, the ITU obligation forms the subject matter of their friend obligation, and that is something to which the court can have regard when determining the friend licence. And in my submission, if an action was brought, as it were, as a positive patent case, would have to have regards to, because our response, our defence to a patent case would be, well, we want a friend licence. And Huawei and ZTE requires a patentee in this circumstance to make a friend offer to an implementer before an action is brought. So if I can put it another way, it's a combination of the bringing of a patent claim and the abuse of a dominant position, which the effect of which means that the patentee is required to offer us a friend licence, according to the Huawei and ZTE decision, that gives us which gives us the right to rely upon the ITU undertaking as to the grant of such a friend licence. And that is, in my respectful submission, the same as in the other telecoms cases, and it's certainly the way it's approached in the German telecoms cases, where the German courts say a patent, rely very heavily on the Huawei and ZTE decision to say a patentee must, at the outset, make a friend offer to a licensor, potential licensor, before bringing a claim. And the reason they have to do that is because it's an abuse of dominant position if they don't do so. And we say this claim is just the reverse of that. We are trying to preemptively determine the scope of this defence to a claim for patent infringement under the UK Standards Essential Patents.
And do I understand you to say that that submission, that the patentee must make a friend offer to the implementer before bringing a claim for an injunction, does not depend on the implementer having a contractual right under the undertaking to enforce the undertaking?
I do, and if one looks at particularly the German cases they never discussed French law and the contractual obligation that arises in respect, for example, of EWCA. They treat this, and as the Court of Justice treated it in Huawei and ZTE, as a matter of competition law. There's a famous three-stage test that arises in Huawei and ZTE, which is step one, the patentee must make a friend offer to the defendant. Step two, the defendant. Sorry, I think I've missed out step one. I think I've actually got that wrong. Yeah, so the first thing is, the patentee must send a notification to the potential defendant saying, these are my rights, you need to be aware of them. Step two is then the patentee.
Implementer has to say, I want a license.
I think I better check this over the shorter German when I get there, my lord. I'm mucking up my three-stage test, but certainly the steps do involve the patentee saying an obligation on the patentee to make a friend offer to the defendant. And then the next step is that the defendant has to respond with a friend offer and engage proactively in negotiation. And this is all as a matter of competition law. It's not as a matter of enforcing a contractual right.
So you accept that the obligation you're talking about here now, the one you've just described to my lord, is an obligation that arises out of competition law. It's a legally enforceable obligation, and under Article 102, abuse of dominance, that a patentee has to do that.
I do, but it is not the abuse of dominance that was pleaded and is no longer pursued.
No, you haven't pleaded that abuse of dominance either.
No, I haven't, that's right. But the abuse of dominance only arises as and when they actually bring the patent claim against us. So there is a condition precedent that hasn't arisen here. So that is correct, but the reason it's not pleaded is because the abuse of dominance hasn't yet crystallised.
If they did the thing which you say they need to do under Huawei and ZTE, the Court of Justice's decision in Huawei and ZTE, whichever the three steps are, doesn't really matter, but let's say notify first. If they didn't do that, then then the legal wrong which would be committed is an abuse of dominant position, which would give you a right to sue them for that abuse of dominance.
Yes, and but my lord, that's why I said right at the outset when characterising my case that the main purpose of the primary benefit of a declaration we refer to is that if an action was brought against us in the UK without offering us the FRAND licence determined by the court, that would in effect be demurrable. We would say we are entitled to a licence on FRAND terms, and you haven't offered it, and that's demurrable under Article 102. So
your entitlement, sorry, Mr. Chatsfield, what you're telling me, as I understand it, is your entitlement to a licence under FRAND terms is an entitlement that arises under competition law. It's just that you haven't said that in your particulars of claim anywhere.
It would be an entitlement under competition law as and when they assert against us, as and when they actually bring the patent proceedings against us. That's correct. But my lord,
do we have Huawei and ZTE?
I'm not sure we do have it in the bundles, but I'm sure it will be referred to in one of the cases. I'll be able to find you the relevant section over the shorter Germans. I'm sure it will be cited in Unwired Planet and Conversant and many others.
Okay, thank you. But it's a CJEU decision.
It is. And it's one that's solely based on competition law. So, going back to what my Lord Justice Birss said, it is true that the complaint in competition law that this declaration is directed to has not yet crystallised because a claim has not been brought in the UK. But this is, in my submission, in the same way as apprehended patent proceedings can be addressed by way of a proactive defence in the Arrow cases. In my submission, the same is true here, in that a defence can be proactively established or its scope and extent established in advance of the patent claim actually being brought and the Article 102 case actually being crystallised in this context. And I will show you those Arrow cases after the short adjournment.
Yes, Mr. Chatsfield, I'm sure that you and all the other counsel and my Lord Justice Birss know exactly what an Arrow case is.
Sorry. So yes, sorry, an Arrow case. An Arrow case is essentially this. It is brought where a party apprehends that patent proceedings may be brought against them in the future based on as yet ungranted patent applications. And what the defendant does in those circumstances is they seek a declaration from the court, which is that their own allegedly infringing product was either old or obvious at the relevant date for the patent, what's often called the priority date. So it's a declaration of either pure fact, if it's a declaration that the product is old, or a declaration of mixed fact and law, if it's a declaration that the product is obvious. But the purpose of it is that if a patent is later granted and asserted against the defendant, then the patentee is hung on the horns of a dilemma. Because either the scope of the patent claim is such as not to encompass the alleged infringement, in which case there is no infringement, or the scope of the patent claim is sufficient to encompass the alleged infringement. And if that is the case, then ex hypothesi, because of the declaration, it covers something old or obvious and the patent is invalid. So it sets up what is often called a Gillette defence. But what it does is it's a preemptive creation of a defence to future patent infringement. And what's more, what the Pfizer case shows us, and we'll have a look at this, is that you can, in some circumstances, obtain arrow relief, even if there never will be patents granted in this jurisdiction, if it serves a useful purpose in accordance with the FSA and O'Rourke criteria. And one of the cases that's referred to in the bundles, in the cases in the bundles, is one known as AbbVie, Fujifilm and AbbVie. And we have an interlocutory decision for Fujifilm in the bundles. But what happened at trial before Mr. Justice Henry Carr is that it was determined that due to certain undertakings given by AbbVie, there never would be UK patent rights of relevant scope. But nonetheless, the declaration in Fujifilm was granted because of the confusion that had been created in the marketplace by AbbVie, and because in the light of that confusion, it was held that the declaration would serve a useful purpose.
So, Chancellor, would you accept that as a summary of an arrow declaration, it's a declaration of non-liability in tort?
I would accept as a declaration that preemptively establishes a defence.
It demonstrates that the person is not liable in tort to the patentee.
Well, yes, it demonstrates that the person, that the patent will either be valid or invalid or not infringed. It's not in terms a declaration of non-infringement.
No, I know, I didn't say that. That's why I said not liability in tort, because that's what it is.
Yeah.
The reasons why that you've explained to my lord and my lady, I suspect don't matter very much, which is why I'm trying to cut it short. Because I don't think it really matters very much whether it's what Gillette is and any of that. What matters is, at least it seems to me, that an arrow declaration is a declaration that the party getting it is not liable in tort to the defendant. And that may be the UK tort of, in terms of the infringement of a valid patent, or it may be a tort in some other foreign country for infringement of a valid patent in a foreign country. But that's what it is.
It is, but I would draw two other points out of that, my lord, which is, firstly, what it is a straight, what it in fact is a straight declaration of fact, or mixed fact and law. It's about the nature of the patentee's product. It's not a declaration of non-liability in the kind of taxatory sense where the court will actually say you're not liable. It is just a declaration of fact. And it has to be in that form because of the effect of what Section 74 of the Patent Act would actually bar a declaration of a more standard declaration of non-liability. And the other point I draw out of it is because it's a declaration of fact which establishes a defence, and the result of the defence is non-liability. And that's why I do draw an analogy with the present case, because in my submission, what we're seeking to do here is get a declaration of fact or mixed fact and law, which is namely the scope of the Frown licence, which would serve to provide us with a defence to a future claim of patent infringement.
Yes. Is that a convenient moment, Mr. Chaxfield?
It is, my lord and my lady. Yep.
Yes, I'm afraid we've been asking you some questions, which simply illustrates the unfamiliarity with the subject matter. How are you doing on your timetable?
Okay, I will have to try and speed up a little. I was hoping to actually run under today, but I have had maybe not made as much progress as I would have liked. I'm about on course, and I would hope to finish on time, although I may have to be a little briefer on some of the subjects.
We'll try not to derail you too much. We'll say 2 o'clock.
Great, my lord.